and this is Kenton Knows. In this video, I'm going to explain my thoughts on deciding between charging a move-in fee versus holding a security deposit. If you like this video, please hit the like button, leave me a comment, and consider subscribing to my channel. Before I dive into this topic, I thought I'd touch on how I believe the move from security deposits to move-in fees started. As anyone who has been in the business for a while knows, security deposits were the standard. Back when I bought and managed my first property in 2003, I held security deposits. Then, when a tenant moved out, I would calculate the interest due on the deposit, put together an itemized list of repairs needed, then write them a letter showing the deposit plus interest minus repairs, and send the balance with the itemized letter to the tenant's new address. I would also include some verbiage under the signature line on the back of the check, stating that by cashing the check, they agreed to the terms and released me from any future claims, etc. That was the old way. Then, in an effort to better protect tenants, the City of Chicago updated the Residential Landlord and Tenant Ordinance with rules regarding security deposits, among other things. As rents started to climb, attorneys started reaching out to tenants to chase landlords for violating the ordinance. One small misstep by the landlord with regard to the security deposit could result in a judgment of 2 times the security deposit plus interest. There are many ways a landlord could unintentionally violate one of these steps. So in my opinion, the stricter law had the unintended consequence of landlords moving away from security deposits and replacing them with non-refundable fees. I personally made the change over 15 years ago, and I have to say it was the right move. There is obviously a lot less administrative work to collect one move-in fee than to collect a security deposit, place it in the correct account in the specified time, issue a receipt to the tenant, have them acknowledge receipt with their signature, then calculate the interest, do a unit inspection, create a list of damages, issue a letter, and a check to the tenant, potentially argue with the tenant over the refund, and be subject to twice the security deposit. There also seems to be the added benefit for the tenant that they don't have to come up with 2 or 3 months of rent for a new apartment while they're currently paying for the place they are currently living in. Even though it is non-refundable, it is a lot less than what they would have had to come up with if there was a security deposit. Instead, I take the move-in fee as income before the tenant even moves in. Then, when the existing tenant moves out, I pay for the repairs and cleaning as an expense. I move on with the new tenant. Much cleaner, simpler, and easier than the old way. When the old tenant moves out, we part ways unless the tenant did some significant damage. Otherwise, we don't have any further interactions. No argument or debate over little things or issues. I just clean and repair the minor issues, and we both move on. I started out with a move-in fee of $500 per unit, but now I have increased it to around $800 per unit. I think the move-in fee should be about a third of the monthly rent, but keep it at a round number as it's just easier for everyone. A lot of tenants really seem to prefer the move-in fee, and I haven't had anyone balk at it in many years. I believe from a tenant's point of view, they don't have to come up with the full 2 or 3 months of rent to secure a new apartment, and they don't have to worry about what I may or may not return to them at the end of the lease, as we don't know each other at all when we are signing the initial lease. Instead, it's now just 1 month's rent plus a third of 1 month's rent, which is easier to come up with when you have to pay it up front prior to moving out of your current apartment. For a landlord, I know the worry is, what if the tenant destroys the apartment? Well, if you did a good job with your screening, you should have the tenant's social security number, and if you require a fairly high credit score, the tenant won't want to potentially impact that score. Now, you can't hold a tenant responsible for wear and tear, as that is normal. If the tenant leaves some holes in the walls or deep gouges in the walls, I wouldn't even bother making it an issue, as some patching and painting is fairly normal and not very costly. However, if they break a door or a sink or really damage the tile or countertop, then you might want to make it an issue. In this case, I'd first start by contacting the tenant and trying to work out something. If they can even pay half or 3/4 of the cost, I'd just take it and move on. Or I'd settle for a payment plan if they can't pay at all. If they won't pay for anything, then the next step is to let them know you'll be reporting them to the credit agencies for the outstanding debt they owe you. If they have a good credit score, they will want to maintain their score, and this may help you make a deal. If that doesn't work, you have an option to take them to court, and if you win a judgment, you can garnish their wages. Or another option is to report it to the credit agencies and work with a collection company to collect the debt. If you go this route, it's best to find someone who will do it on a contingency basis, as it is very hard to collect the debt. As a last resort, if it is over $600, you can forgive the debt by reporting it to the IRS with a 1099-C form. This lets you write it off as a loss, and the IRS will charge the tenant taxes at their tax rate on the forgiven debt. In summary, I believe the move-in fees are more efficient and better for both the landlord and the tenant. There is less ambiguity, fewer arguments, and it doesn't require the tenant to have a large upfront payment. I also believe that the best route to avoid any issues is to screen your tenants well. Then, if there is an issue, do everything you can to work it out with that tenant, even if it is only a partial payment plan. Court and collection agencies are your next option, but those options really aren't good for the landlord or the tenant, with the costs usually outweighing the benefits for both sides. Then, the last resort is to forgive the debt by reporting it to the IRS with a 1099-C form. Also, as a side note, there is a current pending bill in Illinois, HB3564, which aims to eliminate move-in fees and restricts credit checks to a maximum of only $20, which is absurd. If you are in Illinois, even if you aren't, please contact a state representative and ask them to vote against this bill. The unintended consequence will be that housing costs will go up, not down, and your expenses to manage your properties will go up, which means you'll need to raise the rent due to this new law. If you like this video, please hit the like button and consider subscribing. If you have any questions, please feel free to ask them in the comments below. If you found this video useful, please like and share it with someone else who might enjoy seeing it. Thank you for watching Kenton Knows, and I wish you the best of luck with all of your real estate investments.